Contented Media presents Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. An original podcast series with Mark Hunter and Arthur Van Pelt.
Craig Wright is an Australian computer scientist at the heart of a multi-billion-dollar battle to see who owns Bitcoin. Not the cryptocurrency, the brand. Wright has been trying to get himself recognised as Bitcoin's pseudonymous creator Satoshi Nakamoto for over 7 years, but having failed in the court of public opinion, he has recently taken his battle to bricks and mortar courts as he attempts to sue his way to being awarded ownership of the Bitcoin name and the trillion-dollar ecosystem that comes with it. Wright's supporters claim he is undoubtedly the creator of Bitcoin, while his detractors believe his claim to the Bitcoin throne to be based on nothing but a phalanx of lies and forgeries, supported and funded by a billionaire casino magnate. Throughout this series, myself and my co-host, semi-professional Craig Wright debunker Arthur Van Pelt, will take you through the incredible story of Craig Stephen Wright and his attempts to claim ownership of the financial revolution that is Bitcoin. This is not a story about Bitcoin, blockchain, or cryptocurrencies. This is a story of David versus Goliath, of the extraordinary lengths that Craig Wright is going to try and seize ownership of the Bitcoin brand, and the damage that is being done to regular people along the way. This is episode 8, The $1 Trillion Trial. Hello and welcome to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, the podcast that does indeed lift the lid on the efforts of Mr. Craig Stephen Wright to gain acceptance as Bitcoin's creator, Satoshi Nakamoto. My name is Mark Hunter, author, blockchain writer and podcast host, and it is my job to guide you through the morass of events, claims, counterclaims, lies, thefts and lawsuits that all go into making up this, at times, unbelievable story. As usual, Arthur is here to help sort the truth from the tales as we burrow ever deeper into the rabbit warren that is Craig Wright's claim to be Satoshi Nakamoto. Arthur, is your nonsense detector charged and ready to go?
Yeah, for sure. And I also have a robot hoover ready here to clean up the mess after we have done this episode, Mark. Let's go.
Fantastic stuff. Okay. So, in the last episode, we discussed Wright's deposition in front of Judge Reinhardt, who had summoned Wright to give testimony in a contempt of court charge. Judge Reinhardt had accused Wright of failing to comply with 2 orders: to produce a summary of his Bitcoin holdings as of 31st of December 2013, and to produce a list of the addresses he said he mined Bitcoin to between 2009 and 2011. Wright's documentation supporting his Tulip Trust claims was pulled apart by a forensic expert who proved that a great many of the documents and emails had been faked, with Wright claiming that all the forgeries were down to other people hacking into his systems or people in his organisation not filing paperwork properly, again and again and again. The deposition also revealed for the first time that Wright was a multiple trustee for the Tulip Trust, despite telling the judge he had never been one, with access to the trust and its billions of dollars worth of Bitcoin and intellectual property divided up into 4 shares and split up using a Shamir sharing scheme. Wright argued that the deed of trust that pointed him out as trustee 4 times over could have been for one of any of the 4 shares and didn't necessarily point to the Bitcoin at the heart of the contempt of court hearing. Wright's hearing was spread across 2 days, after which Judge Reinhardt was left to work up to a ruling he delivered on August 27, 2019. And boy, did he deliver it. The court deems the following facts to be established for purposes of this action. Number 1. Dr. Craig Wright and David Kleiman entered into a 50-50 partnership to develop Bitcoin intellectual property and to mine Bitcoin. Number 2. Any Bitcoin-related intellectual property developed by Mr. Wright prior to David Kleiman's death was the property of the partnership. Number 3. All Bitcoin mined by Dr. Wright prior to David Kleiman's death was property of the partnership when mined. Number 4. plaintiffs presently retain an ownership interest in the partnership's Bitcoin and any assets traceable to them. Arthur, what did this mean for Craig Wright?
You already mentioned it. In fact, he thought and he observed it as the ruling as an obligation to share half of his imaginary and non-existent Satoshi stash with Dave Kleiman. At least that was his first response to Modern Consensus, who had an exclusive interview with him straight after the ruling of Reinhardt.
It's important to note here that this wasn't a formal ruling. It was a recommendation Judge Reinhardt made to Judge Bloom, who was in overall control of the case. Judge Reinhardt had recommended to Judge Bloom that Wright should hand over half the Bitcoin supposedly held in the trust, as well as half of the other assets that Wright had taken from W&K, but this was just the tip of the iceberg. What really made eyes pop out of heads was Judge Reinhardt's summaries of Wright's behaviour during the trial. Dr. Wright's story not only was not supported by other evidence in the record, it defies common sense and real-life experience. Consider his claims. He designed Bitcoin to be an anonymous digital cash system with an evidentiary trail. He mined approximately 1 million Bitcoin, but there is no accessible evidentiary trail for the vast majority of them. He is a latter-day Dr. Frankenstein, whose creation turned to evil when hijacked by drug dealers, human traffickers, and other criminals. To save himself, he engaged David Kleiman to remove all traces of his involvement with Bitcoin from the public record. As part of his efforts to disassociate from Bitcoin and so that I wouldn't be in trouble, he put all his Bitcoin and all the keys to it, his story changed, into a computer file that is encrypted with a hierarchical Shamir encryption protocol. He then put the encrypted file into a blind trust, of which he is one of the trustees, gave away a controlling number of the key slices to now deceased David Kleiman, and therefore cannot now decrypt the file that controls access to the Bitcoin. His only hope is that a bonded courier arrives on an unknown date in January 2020 with the decryption keys. If the courier does not appear, Dr. Wright has lost his ability to access billions of dollars worth of Bitcoin, and he does not care. Inconceivable. This was just the start for Wright, whose demeanour and behaviour were also called into question, as were the validity of his answers. During his testimony, Dr. Wright's demeanour did not impress me as someone who was telling the truth. When it was favourable to him, Dr. Wright appeared to have an excellent memory and a scrupulous attention to detail. Otherwise, Dr. Wright was belligerent and evasive. He did not directly and clearly respond to questions. He quibbled about irrelevant technicalities. When confronted with evidence indicating that certain documents had been fabricated or altered, he became extremely defensive, tried to sidestep questioning, and ultimately made vague comments about his systems being hacked and others having access to his computers. None of these excuses were corroborated by other evidence. Compare this to the judge's summary of Wright's behaviour during a 2004 court case. The probative force of the new evidence depends in large measure on Wright's credibility and reliability. His explanations and interpretations of these and related documents are contradicted at critical points, on which there is no independent evidence to support him. The appellant's contradictory evidence about the email of 11:16 a.m. on 10th September 2003 raises doubts about his credibility, as does his evidence based on the calls from his mobile phone that day. Arthur, as we can see, nothing has changed in those 15 years, has it?
No, we can clearly say that. Allow me to add another one of those findings by a judge. For example, where Craig Wright acted as a witness in the Reliantco lawsuit. We have a nice quote from that final ruling also. Dr. Wright gave evidence. He was an unsatisfactory witness in many respects. He was belligerent, argumentative, and deliberately provocative. He evaded questions to which he did not wish to give a straight answer. On occasion, he refused to accept what documents plainly indicated. He was prepared to make grave and unsustainable allegations, for example, in relation to the supposed fabrication by or on behalf of Reliantco of an email from him of the 3rd of September 2017. He sought on occasion to blind with computer science. I came to the conclusion that I could not rely on Dr. Wright's evidence as to whether and how particular events had happened unless it was supported by documentation, other evidence I could accept, or by the inherent probabilities. So yeah, I guess it's fair to say that Craig is not very impressive court appearance over the years. And yeah, I'm being friendly here, I think.
Judge Reinhardt continued with his character assassination of Wright, saying that he had a strong motive to lie and to hide his Bitcoin holdings, that he continued to take directly conflicting factual positions at different times during this litigation, and that he may be motivated by positions taken in the W&K court cases in 2013, from which he cannot now recede. This is an example of someone else spotting what many familiar with the Craig Wright story already knew. He began rolling a snowball downhill in 2013, a snowball that had been increasing in speed and size ever since, and one that had now hit him full in the face. Judge Reinhardt also had a good time digging into Wright's evidence. There was substantial credible evidence that documents produced by Dr. Wright to support his position in this litigation are fraudulent. There was credible and compelling evidence that documents had been altered. While it is true that there was no direct evidence that Dr. Wright was responsible for alterations or falsification of documents, there is no evidence before the court that anyone else had a motive to falsify them. As such, there is a strong and unrebutted circumstantial inference that Dr. Wright willfully created the fraudulent documents. When it came to the subject of sanctions, Judge Reinhardt discussed the efforts of Steve Shadders to recover the addresses, stating that Mr. Shadders' efforts demonstrate a good faith attempt by Dr. Wright to comply. If Wright thought he was getting away that easily, however, he was to be mistaken. I find that counsel reasonably relied on Dr. Wright as a source of information. I find that Dr. Wright alone is fully responsible for any evasion, incomplete or false representations to the court, or non-compliance with the court's orders. There is clear and convincing evidence that Dr. Wright's non-compliance with the court's orders is willful and in bad faith, that plaintiffs have been prejudiced, and, particularly given the extended pattern of non-compliance and its egregiousness, a lesser sanction is not adequate to punish or to ensure future compliance with the court's orders. Therefore, sanctions under Rule 37b are warranted. Judge Reinhardt eviscerated Wright over 9 pages, detailing the multiple occasions when Wright perjured himself, gave conflicting evidence or testimony, and misled his own counsel. The cryptocurrency world went into a frenzy, with the news also making the same mainstream newspapers that hadn't covered Wright since his first filing in February 2018, once again bringing up his checkered past. Wright's sugar daddy, Calvin Ayre, didn't seem to grasp the concept of the outcome, however, when he tweeted with reference to a forthcoming book about Craig Wright. They started promoting the book that will have the background of Craig creating Bitcoin. It's nice timing to be out at the same time as Craig gets the Satoshi coins out of the Tulip Trust. It's also good timing with Judge just ruling Craig is Satoshi. Arthur, what is this book that Ayre is talking about?
At some point, if I remember well, in 2018, maybe early 2019, a book was announced that was supposed to come out in January 2020. Coincidentally, or not, this was also the month that Craig Wright was supposed to obtain access to the Tulip Trust Bitcoin. It was called Behind the Mask, Craig Wright and the Battle for Bitcoin. And it was for pre-sale on Amazon at that time, with a raving marketing narrative. I'll read it for you. Blackmail, police raids, hidden fortunes, death threats, and a billion-dollar offshore trust. This is the thrilling, stranger-than-fiction story of Craig Wright, the Australian who controversially claims to be the real Satoshi Nakamoto, the elusive inventor of Bitcoin and the underpinning technology that is proving as disruptive as the web was 25 years ago. Behind the Mask spans continents and features a cast of characters ranging from a libertarian femme fatale to a fugitive Canadian gambling tycoon. It follows Wright from his humble beginnings in dirt-poor Queensland to besotted guru trying to recover his reputation and control over the cryptocurrency stage, squaring up to multiple enemies. Painstakingly researched by 2 international journalists, Behind the Mask is the secret history of Bitcoin, which, it turns out, is as much about betrayal and human weakness as it is about a world-changing technology.
Wow.
And you might remember that Calvin Ayre promoted it as the book that would reveal Craig Wright as Satoshi Nakamoto. Unfortunately, it ended as a nothing burger, and we have many of them with Craig Wright, of course. So this was one of them. The authors decided last minute to not publish this book. So that was January 2020. I remember them citing a fear for legal consequences. So yeah, it makes you wonder what happened behind the mask or behind the screens that made Byron and Jeremy decide to not proceed with this book. It has never become known who were threatening them.
Coming back to the lawsuit, Wright's first public appearance following the ruling came on August 30th, where his attempt at laissez-faire didn't come off overly convincingly.
Once again, we're very lucky to have Dr. Craig S. Wright with us today, Chief Scientist at nChain and inventor of Bitcoin. Craig, how's it going?
Not too bad. Here it's a lovely sort of between summer and autumn type day. Got myself a nice cup of coffee. Weekend's coming up. Not too bad.
Okay, so tell us about the court case then. Presumably that's going to take up most of your time in the next few days?
I've got papers I've got to get into my supervisors for my PhDs, which probably sounds strange to most people because they say PhDs, not I'm doing multiples. I've got exams coming up in October. I've got presentations for a conference. I'm presenting 4 papers in next week. I've got the normal patents and everything like that to be filed to keep going. Yeah, life's busy.
The court case, Craig. Tell us about the damned court case.
There's no journalists in crypto media I found. Basically, there's a whole lot of fake news paid trolls. I mean, part of the whole creation of Bitcoin is the commercialization of the internet.
Forget it.
This anti-government thing people talk about.
Eagle-eared listeners will remember that this last section comes from an interview we played you in episode 5, where Wright goes on to describe how in a few months people would realise that court orders could be used to freeze Bitcoin holdings on public addresses on the Bitcoin blockchain, and then force Bitcoin developers to rewind transactions with these Bitcoin holdings, just months before Wright himself sought to obtain a court order to freeze and return 110,000 Bitcoin to him, which he claims were stolen. Wright gave another interview after the ruling to website Modern Consensus, where, again, he referred to this idea of court orders freezing the Bitcoin blockchain, saying, "If the court makes an order, I will comply with the order, and the court has made an order. It's that simple," something the interviewer equated to breaking in to the Tulip Trust. Arthur, what do we learn about Wright from these interview clips?
What we learn here, again, is that Craig does not understand Bitcoin on a fundamental level. He makes several misconceptions here from technical, economical, social, as he does not understand how consensus works. And as we all know, law follows consensus, not the other way around. Coins on the Bitcoin blockchain, they don't get frozen that easily, let alone that developers can be forced to move them. Bitcoin is pretty much decentralized, as designed by Satoshi Nakamoto. If Bitcoin would or could be frozen or moved by outside forces without consent of the holders, could be taken away from you, from anybody else who is holding them, who is having them in cold storage, who has them locked in smart contracts, who is using them for payments. You are at that point not certain anymore about one of money's most important features, and it is fungibility. So what Craig Wright is not realizing, it takes a majority consensus out of 3 major stakeholders in Bitcoin to find equilibrium in freezing and moving Bitcoins. It are the users, the developers, and the miners. There's not a snowflake's chance in hell that Craig Wright, or anyone else for that matter, can get this type of consensus done. All these 3 groups have to agree on that. This is not going to happen.
CoinGeek dealt with Judge Reinhardt's order by successfully missing the point entirely and warning that the Kleiman estate will have to sell off some of those assets to pay taxes, possibly causing a market crash. This came with the added warning that, to get ahead of that market crash, Dr. Wright may sell some of his Bitcoin assets while they are still at maximum possible value, so that he can pursue the development and charity goals he's previously stated. Ah yes, that 1 billion poorest people in the world that Wright had promised he would give all the Bitcoin from his Tulip trust to, the same trust that had been exposed as a fabrication dating back to October 2014. The issue of a potential tax bill came up again later on, with Wright victim blaming, saying, "Everyone wants to hate on me. This is the result. If you'd left me alone, I would have sat on my f***ing money and you wouldn't have to worry. And the biggest whale ever has to dump because he has to pay tax. It's not a transfer. Florida has an estate tax. Trust me, this is not an outcome I would have liked." Of course, this negated the fact that if Wright had been left alone, he would have been theoretically sitting on hundreds of billions of dollars worth of Bitcoin and IP that wasn't his. He should also have known that Florida eliminated its estate tax law in 2005, so that wasn't a concern either. CoinGeek also made an interesting observation over the Tulip Trust. A big point of contention in the case so far has been understanding the private trusts involved, and it appears that the court, the Kleimans, and the Wright camps are still struggling with that. That will have to get figured out before any real conclusion can be reached. Arthur, was anyone really struggling with the Tulip Trust? It seems to me everyone except for Wright's camp were very clear on it.
Yeah, exactly. Because let's bring back in memory that both the ATO already in 2015, same story a few years later in court Florida, already ruled that the Tulip Trust construction was nothing more than a Potemkin village supported by debunked lies and called out forgeries, all rooted in Craig Wright's tax fraud in Australia from the 2013-15 era. And this Tulip Trust was only set up to help advance this tax fraud. It does not exist. It's a paper-only backdated nonsense setup, so to say. There are no encrypted files. There is no Bitcoin whatsoever. It's that simple.
Judge Reinhardt's recommendation was put to Judge Bloom for her verdict, although it seemed the following month that this might not be necessary after settlement discussions between the two camps began and, initially, seemed productive. However, these discussions broke down in acrimonious circumstances weeks later, with each side blaming the other for the collapse, leaving Judge Bloom to decide if Judge Reinhardt's sanctions and the 50-50 split ruling should be enforced. January 1st, 2020 came and went with, shock horror, no sign of the bonded courier. There was, however, a ruling on Wright's sanctions appeal, which had been lodged in November following the blistering attack on Wright from Judge Reinhardt. Wright's counsel had claimed that Wright did not willfully mislead the court by not handing his Bitcoin holdings and mining addresses over, but instead did all he could to procure them. They were also upset by Judge Reinhardt's character assassination of Wright, saying that the magistrate judge's character determinations should have no bearing on whether he is able to produce the list of Bitcoin holdings. Judge Bloom agreed in part, stating in her January 13th ruling that Judge Reinhardt's actions exceeded the magistrate judge's jurisdiction and authority. She reversed the sanctions order, which automatically meant that the asset split too was put on ice, but that was about as good as it got for Wright. Judge Bloom agreed with Judge Reinhardt about Wright's actions, saying that he had been evasive, refused to give and interpret words in their very basic meanings, was combative, and became defensive when confronted with previous inconsistencies. She also picked up on how long Wright had known that he wouldn't have been able to comply with the court's order, saying that this delay in telling Judge Reinhardt that he couldn't comply wasted both time and resources. Judge Bloom then summarised her impression of Wright's conduct. The court has no doubt that the plaintiffs were prejudiced by the defendant's antics. It is clear to the court that the defendant's conduct was anything but substantially justified or harmless. Defendant's conduct delayed and obstructed the discovery process of this case, wasted valuable time and resources in litigating this issue, and prevented the plaintiff from obtaining evidence that the magistrate judge found relevant to the plaintiff's claims. Therefore, the court rejects the defendant's argument that no prejudice has been suffered by the plaintiffs as a result of the defendant's conduct. Such an argument is entirely devoid of merit. Her attention then turned to the issue of the bonded courier. Given the defendant's many inconsistencies and misstatements, the court questions whether it is remotely plausible that the mysterious bonded courier is going to arrive, yet alone that he will arrive in January 2020, as the defendant now contests. However, given that the defendant maintains that he should at least be afforded this opportunity, the court will indulge him this much. the court will permit the defendant through and including February 3rd, 2020, to file a notice with the court indicating whether or not this mysterious figure has appeared from the shadows, and whether the defendant now has access to the last key slice needed to unlock the encrypted file. Arthur, you've already mentioned that this is one of several judges that have accused Wright of factual inconsistencies in his evidence, among much else. This means that it's no longer you or I or Johnny and the Butchers saying that Wright is a liar and a fraud. These are district judges, in one case a high court judge, and yet people still swear blind that he's a victim of an unproven decade-long persecution.
Amazing, isn't it? I have no words for the delusions that these people must have to keep entertaining the idea that it's all real. That how can they keep this fake Toshi saga alive? Again, I have no words.
I mean, it's almost as if all these judges who are paid to and their careers revolve around judging things and looking at things on their merits. They make it think that they are either lying or all wrong, and this one person is right. I don't know why people die on a hill like this.
Yeah, exactly.
With a new deadline given, the Bitcoin world held its breath. They didn't have to wait long. Calvin Ayre deleted tweet January 3rd, 2020, 2:28 p.m. Craig and I and others are meeting next week to come up with a plan for helping the BSV ecosystem really explode in 2020. It will do this anyway, we just want to pour some more fuel on. Calvin Ayre tweet January 11th, 2020, 7:19 p.m. If a few things happen that I know of, as I expect, BSV will be top 4 by end of Q1. Craig Wright, January 12th, 2020, 7:30 p.m. Funny, but next week we will have a certain submission. I will start teaching how next few weeks. And bonded couriers are not shadowy. Craig Wright, January 12th, 2020, 10 p.m. Next week we file. Already arrived. Indeed, on January 14th, Wright's lawyers filed to say that a third party has provided the necessary information and key slice to unlock the encrypted file, and Dr. Wright has produced a list of his Bitcoin holdings, as ordered by the magistrate judge to plaintiffs today. The bonded courier had arrived. BSV fans everywhere rejoiced and rubbed the news gleefully in the face of their Bitcoin-loving doubters, while the BSV price itself did exactly what Calvin Ayre had magically predicted in his deleted tweet and exploded, rocketing from $164 to $420 in just 48 hours. Had Wright finally proved all the naysayers wrong and cemented his position as Satoshi Nakamoto? Arthur, what did the bonded courier actually reveal?
Yeah, the famous bonded courier story. Yeah. First of all, Craig immediately started to deny in a Slack room where he entertains his little group of followers that he ever said bonded courier. And so I went back to, at that moment, to check the deposition where they discussed the subject under oath and in front of the court judges. And Craig mentioned bonded courier at least a handful of times. So that was already a bit of a funny anecdote. But what came to light was that this bonded courier, he had supposedly sent Craig's wife, Ramona. She was a trustee of this Tulip Trust. And I can already say non-existent Tulip Trust, of course. She received a file that was supposed to disclose the Tulip Trust public Bitcoin addresses, but without the private keys. But those private keys were supposed to be in the encrypted file also, according to Craig Wright's earlier sworn testimonies. So there was also a mismatch already. But when this list of 16,404 addresses was handed over to Ira Kleiman Counsel in January 2020, they also figured out that this list of public addresses contained the so-called shadows bug, as was already found in the shadows list that was filed roughly, I think, half a year earlier. I think we discussed it already in a previous episode.
CoinGeek, which of course reflected the opinions of Calvin Ayre and very little else, seemingly suspected that things weren't as they seemed. With such a revelation as the arrival of the bonded courier, they might have been expected to file some 15 stories about the development, but they were instead oddly cool about the news and refrained from predicting the end of days for the rest of the cryptocurrency space, saying, "This news has important ramifications for the case and for Bitcoin itself. It proves that Dr. Wright has not been trying to deceive the court in any way, but simply needed to wait for January 2020 for his Bitcoin to be returned to him. It would also of course prove that he's the creator of Bitcoin, provide him an incredible fortune to continue building on Bitcoin SV with, and discredit the critics who continue to insist on BTC being the real Bitcoin. With this monumental news and many other documents recently turned over, Ira Kleiman's lawyers need more time to sort through everything in this phase of the trial. They've asked the court for an additional 90 days of discovery, stretching it out to April 17, 2020. This was a suspiciously downbeat response from CoinGeek, who failed to report any further on the event in the following days, suggesting that there was a reason to keep quiet about it. The Kleiman estate did indeed file for an extra 90 days of discovery, stating in the same document that they had seen the contents of the bonded courier's pouch and been unimpressed by its contents. The document produced by Craig is simply a list of 16,404 addresses. Craig, however, did not provide any information on the bonded courier, the company he or she worked for, when he or she came, or the message delivered. Plaintiffs request that they be provided with 7 interrogatories about the courier that Craig must respond to in 10 days. Plaintiffs will then use those responses to seek discovery from the bonded courier and his company. In the interim, plaintiffs are having their experts review and analyse the list. Plaintiffs expect that they will be ready to depose Craig after this discovery occurs in early March. The bonded courier revelation was suddenly feeling a bit like a 3-day-old balloon, especially given that Wright was expecting access to the public addresses as well as the private keys to these public addresses. Had Dave Kleiman messed up Wright's orders back in 2011 and only preserved the public addresses? If so, where on earth were the corresponding private keys? Seeking more answers herself, Judge Bloom allowed the plaintiffs to ask Wright their questions about the bonded courier, with the trial pushed back until June 2020 to allow for the information to be analysed. In March, the world learned the name of the bonded courier thanks to Wright's legal team finally responding to the demands of the Kleiman estate. That name was none other than Dennis Mayaka, Tulip Trust trustee and the man who in October 2014 sold Wright the empty shelf company Tulip Trading Limited that would become part of the Tulip Trust. Dennis Mayaka it was who Dave Kleiman had apparently hand-picked in 2011 to safeguard access to the Tulip Trust 3 years before Wright purchased it from him. This would have been impressive time control from someone who wasn't hospitalised, but for someone as ill as Dave Kleiman was at the time, this is some Back to the Future stuff. Arthur, one of Craig Wright's financial backers during the signing sessions, Robert McGregor, had an email conversation with Wright before the signing sessions took place around April 2016 about the potential of moving the coins. And in that conversation, Dennis Mayaka's name comes up as trustee representing Savannah Limited. This shows that Wright, either directly or indirectly, was in contact with Mayaka at the time. Are we supposed to believe that Mayaka never told him he was the bonded courier in all this time?
The thing is, you're asking me to try grasp a situation that you know that is all made up in the brain of one man who is just filling in papers, who is making paper schemes and dropping names there that sometimes make sense and most of the times makes no sense at all. In other lists, then you will see that he will try to control everything. This Mayaka, the poor guy, might have not even been aware that he was a bonded courier or a trustee or whatever. So what are we supposed to believe?
Let's not forget too that Mayaka was first supposed to deliver his package by contract in July 2014, 15 months after Dave Kleiman's death, but failed to do so. And now magically, nearly 2 weeks after he's missed the second deadline, he finally turns up just days after Calvin Ayre and Craig Wright are promising something big for BSV. What are the odds?
Well spotted, Mark. This is the same types of inconsistencies that we find in courts that are being debunked by Val Friedman and his team, and outside courts by the Bitcoin community. Things like that are being exposed like clockwork.
The Kleiman camp continued to press for details over Dennis Mayaka and, naturally, sought to quiz the man himself over his side of the Tulip Trust affair. Wright's camp demurred, saying that as Mayaka was acting for the Wrights in a legal capacity, he was bound by client-attorney privilege. In a March 9th ruling on a discovery order, Judge Reinhardt addressed this. To establish an attorney-client relationship between Mr. Mayaka and Ms. Watts, Dr. Wright introduced a sworn, unnotarized declaration of Dennis Bossier Mayaka. The declaration states, "I am lawyer and obtained my Bachelor of Law degree in 2007 from Moi University in Kenya." Dr. Wright also introduced a printout of a LinkedIn profile that reflects Mr. Mayaka having a Bachelor of Laws degree from Moi University. Dr. Wright also relies on his own sworn responses to the interrogatories, which assert that Mr. Mayaka is counsel to the trust. You can almost feel the disbelief and scorn dripping from the page. Needless to say, this did Wright's reputation no good whatsoever, either in the courtroom or in the public's eyes. Also, needless to say, Dennis Mayaka's credentials were summarily dismissed by the judge. I disregard the Mayaka declaration because it has not been adequately authenticated. Particularly given my prior finding that Dr. Wright has produced forged documents in this litigation, I decline to rely on this kind of document, which could easily have been generated by anyone with word processing software and a pen. Arthur, I know that Wright and Kleiman didn't have much money in 2011, but is this really the best they could do? A lawyer who can't spell and whose only qualifications come from a LinkedIn printout?
Yeah, this was probably really the best they could do, Mark. Or it's probably better to say what Craig Wright could come up with to keep the trust saga alive.
Yeah, I think he's running out of ideas at this point, isn't he? He's like episode 9 of Star Wars.
Yeah.
The fallout from the bonded courier debacle had the expected effect on the BSV price, which plummeted back to $121, lower than it had been before Mr. Mayaka's arrival. Still, as long as some of the whales managed to cash out at the top of the price spike, it had had its intended effect. Incidentally, Calvin Ayre's prediction that BSV would end Q1 in the cryptocurrency top 4 was, like almost all his others when it came to the project he was bankrolling, wrong. BSV was 6th, worth almost $2 billion less than the 4th placed coin by the end of March. It has dropped over 60 places since. The jury trial was further delayed due to the coronavirus, and as such 2020 saw little of interest in the case apart from a few hearings on discovery and discussions over the witnesses to be called ahead of the trial. That wasn't to say that all was quiet on the Craig Wright front though, far from it. In April, Wright was accused of plagiarising parts of a dissertation written in 2008 as part of his Masters in International Commercial Law at Northumbria University. Someone by the name of Painted Frog took to Medium to show how Wright had either paraphrased or copied word for word huge chunks of content from textbooks and online resources with no references or citations to the original authors, as well as reproducing charts and graphs in the same vein, essentially passing all the work off as his own. These instances were manifold throughout the piece, with Painted Frog highlighting in later updates how Wright was actively amending the piece following his report. Painted Frog uncovered this practice in not just one of Wright's pieces, but 2, with Wright allegedly repeating the process for his disputed 2017 PhD thesis. Wright denied this, giving 3 reasons why the work wasn't plagiarised, including a claim that some of the passages included common terms or common words and commonly used diagrams, which he didn't need to attribute. He also argued that the reason some passages weren't attributed to the authors was because he was over the word count and needed to cut something out, so he cut out the attributions. The mind boggles. Something much more germane to the Tulip Trust case occurred in May 2020 involving some of the Bitcoin addresses Wright claimed to own, but that we learned in episode 6 belonged chiefly to big holders on Mt. Gox. Arthur, I'll let you take this one.
The list was checked by people who were the true owners of the addresses. Again, this list only contains the public Bitcoin addresses from 2009-2010, of which Craig Wright says, these are mine, this is my Satoshi list, this is my holdings in the Tulip Trust that prove that I have been mining in 2009 and 10 as Satoshi. So it should technically be impossible that somebody else owns these addresses. The moment this list is being made public, it should be technically impossible that anybody else except the true owner of this list should be able to sign off on that list. But as it happened, 145 times this list got signed by other people, not Craig Wright, not Satoshi Nakamoto either, but I think it is a group of miners that know each other that have been contacted each other. The moment they saw this list in the court docket, they have been sending it around. Hey, can you check if you have an address? Blah, blah, blah. And it ended up that one or more persons had addresses on that list. When they find addresses that they control, but it end up on Craig Wright's encrypted file Tulip Trust list, that is, of course, a spectacular mismatch between how things are being presented by Craig Wright and how they are in reality. If 145 addresses are being signed with the message that Craig Wright is a fraud, but these addresses were all the time in an encrypted file in a Tulip Trust, that is of course technically and socially impossible. That means that for another reason, they found already the shadows bug, but this is another reason why this whole Tulip Trust list is indeed a forgery.
On May 26, 2020, you tweeted, "Up next, Craig will declare the bonded courier was hacked." And this is exactly what happened. Do you have next week's lottery numbers?
Yeah, probably a lucky shot, but on the other hand, when you research this stuff for a while, it becomes easier and easier to predict what Craig's next step will be. And his excuses like the dog ate my homework, they are plenty. And in this case, we have the anecdote from one of Craig's dedicated fans, an individual called Eli Avram, who on behalf of Craig Wright declared on Twitter that Craig stated he received the Tulip Trust list from Dennis, who was hacked. So here we find another discrepancy, as Craig Wright would declare in court that not he, but his wife Ramona, in her capacity as trustee of the Tulip Trust, had received the list. But again, it's all bogus, of course.
Wright addressed the issue of the address signings in June 2020, giving an unconvincing answer before being saved by the bell.
You can't sign, you have to have either an identity attribute or an identity to sign a message. Someone can't go and say, "Hey, I've got a key, I'm signing." If you think that, then you don't understand digital signatures at all.
So you're saying that like somebody's saying Craig Wright is a fraud and this is a message everyone's supposed to take as truth. You're saying that was like not signed?
No, it wasn't signed because that was Antonopoulos's Dread Pirate Roberts defense that got kicked out of Silk Road prosecution, saying you have to sign, you have to register a key, and that has to be protected. And I'm going to have to end because I'm actually over and I've got another meeting that is right now.
Wright's team tried yet again to get the Kleiman case dismissed in mid-2020, once more claiming that the evidence against Wright was insufficient, saying that Kleiman never said or even hinted that he was mining Bitcoin, or that Wright was his business partner, and that Kleiman had no experience in anything related to Bitcoin or blockchain. They also called Ira Kleiman's testimony uncorroborated hearsay. CoinGeek called this submission a bombshell filing, while Calvin Ayre attributed one of Bitcoin's typical 15% drops on the filing. If it was a bombshell, then it didn't go off. Judge Bloom rejected it in September, picking apart every single one of the claims with a fine-toothed comb. In her lengthy response, she frequently cited a lack of evidence offered by Wright to support his claims, adding that what little evidence there was often came in the form of responses to non-existent plaintiff complaints. This dismissal represented yet another failed attempt by Wright's lawyers to get out of the case before it reached court, and it would be the last chance they would get. The case would start on November 1st, 2021. Arthur, it took a while for mainstream media outlets to cotton on to the trial, but what was the standard of reporting when they finally did start talking about it?
When you look at the average mainstream media reporting, one thing becomes very clear. They did not follow the case from the start. They have no idea what the exact list of accusations against Craig Wright are. You cannot expect them to have been putting any effort into diving into the details and in the background of the lawsuit, the intermediate rulings, the mind-boggling evidence of Craig Wright committing perjury, producing fraudulent exhibits by the boatloads. It strongly appears as if they mainly picked up on the false CoinGeek spin. The case is about who is Satoshi Nakamoto, either Craig Wright alone or Craig Wright in partnership with Dave Kleiman. To be fair, I cannot fully blame them also. that they missed the nuances, because as on the surface of it, Dave Kleiman, he passed away in April 2013, as we know, is being presented in the case by plaintiffs as someone who helped Craig edit the Bitcoin white paper. That was, for example, evidenced in the March 2008 email forgery that he, as far as we know, created in early 2014. And supposedly they created and launched Bitcoin together. And supposedly they also mined a fair amount of Bitcoin in the early years together. So plaintiffs presented this in the lawsuit as a so-called oral partnership.
If you're a mainstream media reporter, you're pushed for a deadline. If you haven't done all that research, then you're just going to be bamboozled by these massive numbers, aren't you? You're going to follow the couple of reports that exist out there already, and you're just going to repeat the numbers, and you're not going to look beneath the surface, are you?
Yeah, exactly. That is what's going on.
Listeners to earlier episodes, which should be all of you, won't have to stretch their imaginations too much to come up with the kind of thing that Wright's supporters were saying in the lead up to the trial. All the talk was about how Wright would be proved to be Satoshi, despite both judges saying on multiple occasions that this issue would strictly not be ruled on, while Calvin Ayre was busy telling everyone that Wright had already won before he'd even set foot in the courtroom, and despite him only being there because of the multiple failures of his legal team to get the case dismissed. Something else that was being bandied around, mainly thanks to Wright himself, was the notion that should Wright lose, he would have to hand over physical Bitcoin to the Kleiman estate. But this simply wasn't true, was it, Arthur?
No, certainly not. This was not true, because we've seen proposals for the verdict forms that the jury will use, and all the fields for all the penalties and the punitive damages and etc. It's USD only on all those fields. There is no demand, no request, nothing that indicates that Bitcoin will be used as a settlement for the debts raising after the end of the trial.
The arrogance of the BSV crowd only served to highlight just how brainwashed they had become, given the paucity to date, in both quality and quantity, of the evidence Wright's team had put forth to back up his claims that there had been no partnership with Kleiman. If Wright's case was as watertight as they believed, why hadn't one of the many motions to dismiss been granted, instead, as the judges had said, being based on hardly any actual evidence? This didn't seem to matter. They knew Wright would win because they had been told so over and over again, and, as in all cults, they were fed excuses of why evidence countering their beliefs couldn't be trusted, with everything relating back to those mysterious sabotages of Wright that had been going on right when he needed them to explain inconvenient evidence since 2008. Before we begin reporting on the events of the trial, we should make it known that, unlike in depositions and judicial rulings, full transcripts for trials aren't publicly available, at least not at the time of writing. We have therefore relied on the accounts of those who were present at the time, using their published material to piece together the actions of the trial, which may not reflect all the events that took place. Fortunately, however, many of the arguments made and the evidence presented to support them on both sides were those covered in Wright's deposition and described in episode 7, meaning we've been able to look at them in detail already. We will instead focus on the most original and interesting points from each day, on the understanding that the claims, denials and discussions over evidence we've already covered were covered again in the same way. As with all trials, the first few days were given over to procedural matters, but something interesting did emerge on day 1, which was the use of Wright's Asperger's diagnosis by the defence. Arthur, what was their argument here?
Well, yeah, how they did it, I have no idea, but they found a person called Dr. Klin, I think his name was, who interviewed Craig Wright and several close relatives, family of Craig. And the end conclusion of his expert report was that Craig is not capable of lying because of autism, Asperger's, something. I think it was mostly surrounding autism. Yeah, it's unbelievable.
When it came to opening statements, the two camps set out their arguments, which ran down lines many listeners will by now be familiar with. The Kleiman camp claimed they would prove that there had been a 50-50 Bitcoin mining and IP creation partnership between Dave Kleiman and Craig Wright, while Wright's camp said they would prove that Wright had acted alone. Wright supporters, CoinGeek among them, again revelled in the suggestion that the Kleiman camp was fully embracing the notion that Wright had created Bitcoin, something that we've already discussed but that bears repeating. In the very first filing of the case in February 2018, Kleiman's lawyers said that it was unclear whether Wright created Bitcoin or not, a stance that hadn't changed over time. All that mattered to them was that Wright was involved in early Bitcoin mining with the brother of their client, something that Wright had said on many occasions he had done, claims they were now using against him. The first witness to be called in the trial was die-hard Bitcoin supporter Andreas Antonopoulos, who rejected the advances of Encrypt in 2016 to join Gavin Andresen and John Matonis as witnesses of the signing sessions. Antonopoulos was asked to explain Bitcoin to the jury for some important background, before Patrick Page, Dave Kleiman's former business partner, became the first witness proper to testify. Kleiman's camp showed an email from Wright to Page regarding a company Wright said he and Kleiman had been running, with Wright saying in the email, "The company we ran mined Bitcoin." Wright's team countered this by saying that there was no formal agreement in place, so it couldn't really be counted as a partnership. Arthur, Jamie Wilson was next to take the stand, and he's been painted as a real villain in the piece as far as Team Wright is concerned, hasn't he? What did he say on the stand?
No, what I remember mostly from the Jamie Wilson deposition is that they met, I think, 2011 or 12, and at first Jamie Wilson was in fact employing Craig, and that turned around early 2013 in January. Then Craig was setting up his Bitcoin business. Yeah, he already was having those plans. I think by the end of 2012, he discussed them with Jamie Wilson. He hired Jamie Wilson as a CFO in January 2013. He was supposed to be on the payroll, never got paid, but there's another story. But since the contract was dated January 2013 to set up Hotwire Group. Somewhere in the summer of 2013, Jamie Wilson noticed something was changing with Craig. He was suddenly less geeky, less nerdy, as he would describe Craig. He was more flamboyant, more outspoken, more full confidence, and apparently suddenly very rich. This happened roughly in July, most certainly after Dave Kleiman died. He would spend a lot of money on things, expensive things, new car, I think, and watches and dinners, and several things have been managed where he would spend in the rest of in 2013, he would spend quite a lot of money on it. And more Bitcoin addresses started popping up in emails and contacts with the ATO, and of course Jamie Wilson tried to do some bookkeeping with that stuff. He did not manage, however, because he was not allowed to touch anything in the bookkeeping. Now, that is already a little bit strange, because if you want to help somebody as a CFO, then of course you need to check the figures every now and then and make a correction and ask your assistant to enter corrections in the system if the figures are wrong. At some point in October, Jamie Wilson became fully aware that Craig was actually doing with the Hotwire Group, with all the companies that he had raised that were falling under the Hotwire Group. He saw the first tax returns probably coming in pretty large amounts. He noticed there is fraud going on here, and he resigned almost immediately after noticing this, and that was in October 2013.
Wilson inferred that Wright had the means to pay for the settlement should it be required, given the amounts of Bitcoin Wright had told Wilson that he possessed, although he couldn't say where it came from. On cross-examination, Wright's team pointed to an email from Wilson to Kleiman's legal team in February 2018 congratulating them on serving Wright, all of which was done to try and undermine Wilson's credibility. Wilson testified against Wright to the ATO in 2013, indeed stating that he was uncomfortable with the fraud that Wright appeared to be perpetrating with his company tax affairs. Wilson's evidence indirectly led to Wright's then legal firm, Clayton Utz, dropping his company De Morgan as a client in 2015, following serious concerns about the integrity of documents provided by Dr. Craig Wright to the ATO. It's understandable, then, why Wright's team have painted Wilson as public enemy number one ever since, and have pegged him as the man behind 8 years' worth of hacks, thefts, and other actions supposedly perpetrated against Wright, instead of Wright being behind them himself. until Ira Kleiman became public enemy number 1, of course. Then it was all his fault. On day 3, Ira Kleiman himself took the stand, which would be the first time almost everyone outside his legal team had heard him speak personally about the case. Kleiman retold the story about how his email conversations with Wright began cordially but quickly degenerated into the very accusations that made up the lawsuit, that Wright essentially stole the Bitcoin and the IP from the company he and Dave ran together. On cross-examination, Wright's team did a great job of picking apart the holes in Ira's supposition, proving that there was no written evidence referencing the partnership split between Wright and Dave Kleiman, if indeed one existed. They also brought up Dave Kleiman's will, which made no mention of Bitcoin or any large sums of money that his estate would be entitled to, something they said would almost certainly have been there if it was worth anything. They also mentioned the 300,000 Bitcoin that Wright had said that Kleiman mined on his own, of which there was no record and which Wright had previously said could have been on one of the thumb drives that Kleiman kept with him at all times. Arthur, Wright's team has made great play of Dave Kleiman's multiple drives and devices in attacking Ira's case. What's the story behind this?
Ja, nee, dat is indeed also almost a Tulip Trust-like conspiracy theory, especially in the BSV community, because these drives, they could have contained important information about either Dave's or Craig's Bitcoin holdings and intellectual property. And the accusation at the moment is that Ira has been deliberately deleting all the information from them to basically annoy Craig Wright and lose his stuff. But reality is those devices were empty, have always been empty, and will always remain empty. And especially after wiping them, you will not find much anymore. But they found one text file, I think, with a Bitcoin public address on it. Kind of a little mysterious, but on the other hand, never have there ever been even the slightest of traces found that either Dave Kleiman had something to do with being in the Satoshi team and Craig Wright being in the Satoshi team. So there is already your whole basis has gone. Those devices have never contained anything Bitcoin related except for a text file with a Bitcoin address in it.
The cross-examination of Ira Kleiman ended with him confirming that Dave's partnerships with Wright and their supposed creation of Bitcoin were completely alien concepts to him. Such was the little that Dave had talked about them. Wright's team also brought up the fact that Ira Kleiman had over 30 email accounts of various names, and in some of those email accounts he pretended to be Dave Kleiman, which Wright's team painted as being suspicious and evidence of foul play. As the first week drew to a close, it seemed that Wright's camp had the upper hand, with little actual evidence on hand to back up Ira's claims, and the defence doing a good job of poking holes in his story. Week 2 began with the testimony from BitMessage founder Jonathan Warren over the fact that Wright probably forged messages between himself and Dave Kleiman because the version cited in the images of messages hadn't yet been released, before admitting it was possible, although very unlikely, that Wright could have been using a pre-release version. Other witnesses offered more testimony that Wright had forged documents or told them that there was a partnership between himself and Kleiman, but once again, the lack of definitive proof helped build a picture but didn't act as the smoking gun that would seal the deal, something that Wright's camp again made a big play of. With 5 days having passed, all the focus on day 6 was on Craig Wright, as he finally took the stand to face Kleiman's lawyer, Vel Friedman. He was immediately taken to task over the contradictory statements he had made regarding W&K and the extent of Dave Kleiman's involvement, with Friedman presenting Wright with evidence of these contradictory statements, suggesting that Wright changed the degree of partnership when it suited him, i.e. he told the Australian court in 2013 that he and Dave had a partnership which allowed him to take control of the $56 million worth of intellectual property, but when it came to testimony for the current trial, he said he did it alone. Wright once again argued that the ATO meeting in 2014, where he frequently referred to Dave Kleiman as his business partner, never took place, echoing arguments he had made in his contempt of court hearing in 2019. Wright had tried a similar tactic with a different ATO meeting in the past, only to be told that there was an audio recording of it, something that even Wright's mental gymnastics could not overcome. Arthur, a strong piece of evidence here was a transfer of something like 573,000 Bitcoin sent from Dave Kleiman to Craig Wright. What's the story surrounding this?
This was about one of those forged contracts that Craig Wright created in the early years of his Satoshi cosplay. And that fake contract mentions 250,500 Bitcoin and 323, I think, Bitcoin that Dave Kleiman was supposed to send to Craig Wright. And accidentally or not, this is also roughly half of the so-called Satoshi stash. I'm not sure if that is a coincidence or not. But yeah, of course, this never happened in real life. It was again something that Craig Wright had created to advance his Australian tax fraud, where he had to prove that he was actually able to invest millions in his company's research and development. Otherwise, he could not make it believable to the ATO that he spent anything on research and development, which is a prerequisite to get tax rebates. So during the Kleiman versus Wright trial, a new, if you ask me, a hilarious anecdote popped up surrounding these bitcoins that Craig and Dave exchanged. There was a guy called Fractal Encrypt who was reporting about it, and it was suddenly about testnet, which is for another reason even more hilarious, because in 2009 and 2010, when they were supposedly mining together, Bitcoin did not even have a testnet, because a Bitcoin testnet was not even set up before early 2011. Yeah.
Wright's argument over this Bitcoin transfer was that Dave Kleiman had been doing him a favour and protecting the Bitcoin from the ATO while they were investigating him, and this transfer was Kleiman handing it back to him. Again, of course, there is nothing but Craig Wright's word to take on this, but it didn't help his cause that he had just admitted to deliberately hiding assets from the tax office. Either he did it, or he was lying about the existence of the Bitcoin in the first place. The examination of Wright honed in hard on his battles with the ATO, much of which we discussed in episode 1. These battles ultimately led to ATO investigators believing that Wright had forged and backdated many of his filings to make it look like his companies were solvent, when in fact they just existed to claim tax rebates. Wright argued again that he had been hacked and that the ATO rejected a report from a forensic investigator he hired to confirm the authenticity of his documents. He also said that the investigator involved in the case was fired, although of course that's impossible to verify, and he also claimed to have been hit with 200 audits in 5 years, a figure that, once again, his defence did not provide evidence to support. Wright also claimed that the ATO never charged him with fraud, although it isn't clear if this was part of a previous case that Wright won, or the case that led to his home and office being raided in December 2015, which is thought to be ongoing. Indeed, to date there have been no charges brought from this second case. Yet. It was this investigation, however, that led to Wright's company being dropped by Clayton Utz, although Wright said on the stand that he had been dropped because of pressure from partners at the firm to do so, and that it had nothing to do with fabricated documents. When it came to why Wright took almost 10 months to contact Louis Kleiman about Dave's supposed role in Bitcoin, time Wright used to absorb the Bitcoin and intellectual property from W&K, Wright responded that he had contacted Kleiman's fiancée many times, well before reaching out to Louis. Once again, there was no evidence to support this claim. Arthur, related to the intellectual property, the judge allowed comments made by Wright the day before the trial started regarding the value of the IP Wright owned to be entered into evidence. What's the story there?
Ira's counsel, they have people looking at the Slack room, and they found a message that 252 billion mentioned by Craig Wright, that was supposedly the intellectual property at stake in the Kleiman case. Now, what I remember is that Carolina Bolado, who is the local court reporter, and she was telling the story that when they discussed this Slack room message that was brought in by Ira's counsel, and based on that calculation of intellectual property, they made a new calculation of the possible penalties. It was calculated that the total amount of penalties, including punitive damages, including treble damages for civil theft, it became a number close to $1 trillion. It was crazy.
We don't have a detailed response from Wright over this valuation, with Bolado describing his explanation as long and convoluted, shock horror, but it was reported that Wright claimed the valuation document to have amounted to a misrepresentation. He argued that it was not about the software's value, but was instead about the value of the potential damages that could be brought by claims made against companies for changing the Bitcoin protocol. Convoluted indeed. Wright was also quizzed about his dealings with Ira over the fate of CoinEx, the company Wright expected to get annual tax rebates from if the tax office let him. Wright reiterated how he offered Ira the chance to be a shareholder and be part of the growth of the company, but Ira declined, with Wright explaining that man didn't want to hold Bitcoin. He didn't want to hold assets. He didn't want to build, didn't want to grow. He wanted to strip it, he wanted to loot it, he wanted to take it and basically eviscerate it so that he can sit there drinking Mai Tais. Wright reiterated his claim to have offered Ira $12 million as part of the deal to sell 50% of CoinEx to Calvin Ayre in June 2015, but that Ira had refused and demanded more. Wright added that had the ATO not shut me down, CoinEx would be as big as Coinbase is today. Wright was also quizzed about Dave Kleiman's actual mining involvement, with Wright mentioning the mining of testnet Bitcoin. Wright also made another extraordinary claim about the Bitcoin Genesis block, claiming that if the Bitcoin in it was ever spent, then the entire Bitcoin blockchain would unravel. As far as I know, the Genesis block was specially coded so the Bitcoin in it could never actually be spent. But even if it could, would that cause the Bitcoin blockchain to unravel?
As far as I know, not really. I mean, not that I want to try and test it, but it's impossible to spend for a few reasons. It's hard-coded. The Bitcoin itself is not part of a chain of signatures. In the Bitcoin white paper, it's described that Bitcoin, a single coin, is a chain of signatures. And because this Bitcoin in the Genesis block does not have a previous block, so it's not inside a chain yet, then it has no previous signature.
The final line of questioning was about Wright's wealth. Wright claimed that technically he wasn't a multi-billionaire, but that his wife was, adding that there was a covenant over the Tulip Trust funds which would see the money go towards Wright's idea of helping the world's poorest people if he ever got it back. If Wright has his way, mind you, that category of people could end up including Bitcoin developers. Next on the stand was forensics expert Dr. Matthew Edman, who repeated the testimony he gave in Wright's contempt of court hearing 18 months previously, the details of which can be heard in episode 7. Dr. Edman went through the same emails and documents he had done at the time, outlining the areas that he had identified as pointing to forgeries, including key documents and emails pertaining to the Tulip Trust. On the morning of November the 16th, Judge Bloom was made aware of comments Wright had written in his private Slack channel to his BSV acolytes, just as his attorney was questioning Dr. Edman's use of the word fraud in his evidence. Listeners might remember that Wright's legal team had tried the same argument before Dr. Edman's testimony during Wright's 2019 deposition, where Judge Reinhardt sustained their argument that when Dr. Edman used the word fraudulent, he must not imply that it was Wright who had perpetrated the fraud. Here, they were trying to make the same argument in front of Judge Bloom, during which Wright told his private BSV Slack group, "You know you can sue experts who give misleading testimony, and that they shouldn't make statements of fraud when there is no evidence of fraud." This is an interesting line for Wright's team to take then, given that their contention was that all the fraud was indeed intentional and carried out by a shadowy group that has been trying to wreck Wright's life for years. The Kleiman team accused Wright of witness intimidation, but Judge Bloom rejected this, stating that she was not going to police Wright's comments, other than those that could be interpreted as direct threats. With that, the session could begin, with Edman finishing his deposition and cross-examination, which took the same form as it had in 2019. This was the penultimate act of the plaintiff's case, with the final act being discussion of IP addresses of some of the most incriminating emails from Dr. Edman's testimony, which had emanated from various locations in Australia. Arthur, these IP addresses were new evidence, so they were discussed at length, as was a certain email from the domain rcjbr.org. What were the details about these and their relevance to the case?
Yeah, those are indeed two things that caused quite a turmoil, both in court and outside court. First, let's have a look at that famous March 2008 email. That was an email where Craig appears to have asked Dave's help with editing the Bitcoin white paper. Now, this email has two versions, one from the domain you just mentioned, rcgbr.org, and one from another domain called informationdefense.com. So it's very different domain. So let's make one thing clear here. Both are forgeries, and both came originally from Craig Wright, as they have so-called DFOS codes on the exhibit list. And the DEF in DFOS stands for defense. And in this case, it's Craig Wright, of course. So they did not at any time originate from Ira Kleiman, and that was a suggestion that came up several times, and what circulated also in the BSV community quite a lot. Ira Kleiman had been forging here, but no, that is absolutely not the case. Now, so why are they forgeries anyway? Because, for example, both those domains did not even exist in 2008. Craig only obtained information defense in January 2009. Now, then you cannot send emails in March 2008, of course. And the RCGBR domain, he only obtained somewhere in 2011. Now, so what is interesting here, it appears that this RCGBR version of that very same email about editing the Bitcoin white paper, where Craig asked help from Dave Kleiman. If I remember well, that was sent to Ira Kleiman somewhere in 2014. So that gives you an indication that it has probably been forged by Craig around that time, early 2014. And the version that came from the information defense domain was recreated, I would rather call it, much later, probably in late 2015, because that version popped up also in the Wired Gizmodo docs package. We know how the docs, of course, completely failed, because one of those failures that was already figured out back in 2015 was this email, that it was a forgery, as it was quickly found out that this information defense domain did not exist before January 2009. Now, let's go to those IP addresses that's related to those emails. In this case, the rcgbr.org email came also with the discovery of an IP address. Now, Craig's counsel tried to make the case that this IP address was related to Jamie Wilson. To cut a long story short, Ira's counsel completely destroyed Craig's false narrative about this IP address, as they showed over 75 other, and in this case genuine emails from Craig Wright that contained exactly the same IP address. So it was actually way more likely, and for the insider it's pretty sure, that Craig Wright actually created this forgery himself.
With that, the Kleiman team rested its case. November 17th saw Wright's team begin to offer its defence, but not before filing yet another motion to dismiss based on, you guessed it, a lack of evidence from the plaintiff. This went down incredibly badly with some BSV supporters who had been waiting with bated breath to hear Wright's defence, which they'd been promised for months would be earth-shattering and would prove once and for all that Wright was Satoshi. It didn't matter anyway, the motion was denied again. They would get to hear it after all. The first big topic discussed by the defence was that of hard drives, and Arthur, I'm going to lean on you again here if you don't mind. Their expert Nicholas Chambers of Alex Partners explained how he reviewed forensic images of Dave Kleiman's devices to look for activity after his death to identify any encryption and potentially recover data. Chambers said he reviewed 5 hard drives and 9 thumb drives, finding 3 of the thumb drives to be encrypted with TrueCrypt software, adding that he couldn't access the encrypted files, but that they were all named Do Not Delete. Chambers added that 3 of the hard drives were encrypted, but he was unable to determine what kind of encryption had been used. 4 of the devices were reformatted after Dave Kleiman's death, including a fully encrypted hard drive. On cross-examination, Chambers said he did not find any Bitcoin private keys on the devices, only coming across one Bitcoin public address, although he wasn't able to recover any of the data that had been overwritten after the wiping. Arthur, what was the point of going into these drives, and what was the end result of Chambers' testimony?
Yeah, well, the point was to make it believable if there was evidence on these drives of Dave Kleiman's involvement with Bitcoin. But yeah, as you already said, they couldn't find anything. Allow me to read you the part that explains what he had done. The actions I identified in this report, specifically the formatting and installation of operating systems, are acts that permanently overwrote data previously existing on the devices, rendering it permanently unrecoverable. As such, we will never be able to know the contents of this overwritten information. These actions are potentially rendered any encrypted partitions or containers that were on these devices prior to formatting and installation of operating systems permanently unrecoverable, even if we had or could uncover the passwords or keys to decrypt them. Without these, and possibly even with them, we will never be able to discern what information the devices with encrypted containers or partitions held. Now yeah, again, these devices did not help figuring out if Dave Kleiman had anything to do with Bitcoin, with Craig Wright, and working together with Craig Wright on Bitcoin.
The next witness was Wright's ex-wife Lynn, who, via video link, corroborated Wright's story about working on Bitcoin in the mid to late 2000s, although she added that he never said it by name. Wright's supporters were still waiting for the smoking gun, but they were to be disappointed again when Wright's uncle Donald Linham, also via video link, corroborated Wright's stories about his interest in computers in his youth and his work for gambling companies, adding that Wright would sometimes send him papers, including one that looked clearly to be a digital monetary system, and that he said would later become the Bitcoin white paper. Linham added that Wright told him he created the Satoshi Nakamoto pseudonym from two Japanese philosophers, one of which Wright has previously named as Tominga Nakamoto. However, Wright has never named the person behind Satoshi, telling The Economist in 2016 that some things should remain secret. The only hint we have is a 2019 blog post where Wright says that the name Satoshi signifies wise or intelligent history, so potentially not two Japanese philosophers after all. Linham mentioned the name Hal Finney as someone Wright had apparently worked with at the time of Bitcoin's development, and that Wright never mentioned Dave Kleiman by name before ending his testimony. As genuine as Linham may have appeared, there was little actual evidence offered to back it up. In the words of Carolina Bellardo, he's an uncle who loves his nephew and takes him at his word. Attention then turned to Dave Kleiman, and in particular his health. Texts from Kleiman to a friend show that Kleiman was in so much pain that he could not even go down the hall to get a soda out of the soda machine, and told friends how he felt imprisoned, weak and useless, saying that it had been going on for months. Arthur, clearly this was meant to suggest that Kleiman was in no fit state to have helped mine Bitcoin, but in fact it just throws more light onto the fact that Wright says he allowed Kleiman to take charge of the Tulip Trust, including appointing all the trustees and arranging for them all to get slices of those Shamir schemes, and arranging for the bonded courier, which is something you would not entrust to someone so ill. So this testimony works both ways, doesn't it?
Yeah, of course, for sure. The real story is, of course, that it is all made up to make it look like as if Dave Kleiman did all kinds of stuff, but in reality it never happened. He made it all up after Dave's death in April 2013.
The following day, November 18th, saw the doctor who had diagnosed Wright with Asperger's syndrome, Dr. Klin, take the stand. This had been a bone of contention for Wright's critics, who said that a diagnosis of Asperger's didn't excuse his lying, forgery, bullying and other behaviour he had displayed in the past. Dr. Klin explained the impact that Wright's Asperger's had on his methods of learning and presenting himself, including how he couldn't deal well with social situations, but there wasn't anything revelatory in what he had to say, with the only bearing on the case being that it may have been behind Wright's mislabelling the strength of the partnership with Dave Kleiman over the years, and excusing his misreporting of dates and figures, which has been categorised as lies. A cynic might say that Klin's testimony was used only to elicit sympathy for Wright, something that even Wright's own attorneys would admit in closing was a hard thing to do. Dr. Klin's testimony ran onto Monday, November 22nd, the day that the BSV community had labelled Bombshell Monday. This was the day, apparently, when we would get to see, in the words of Calvin Ayre, a lot of strong fact-based evidence that Craig is Satoshi and that the fraud alleged is in fact most likely a fraud against Craig, not by him. Wright was going to bring out the big guns and provide what Ayre called real legal proof that he created Bitcoin. The crypto world held its breath for what Wright and his legal team had been preparing for almost 4 years. The day started earlier than usual, with both sides wanting to put their cases to bed and get it to the jury before the Thanksgiving holidays, which started the following day. Surely, then, Wright would go for the jugular. A court reporter would later state that there's certainly more documentation presented today than there has been in most of the defence's case. But what did it all amount to? The day started with more from Dr. Klin, including a nice observation that Asperger's sufferers have a tendency for self-incrimination, which by now we can certainly say Wright suffers from. Of course, you have to have done the deed first in order to incriminate yourself. With Dr. Klin's testimony over, the warm-up act was out of the way and the stage belonged to Wright as he took the stand for the second time. Wright started by retelling the story of his youth, which we have already covered in episode 1, before claiming that he had ideas for tokens that could be used for online gambling sites long before Bitcoin came along. He then showed minutes of a meeting from mid-2007 between Wright and one of the companies he worked for, which Wright said was about the Bitcoin white paper on which he was supposedly working at the time. Wright said he started coding the Bitcoin blockchain in early 2007 and had finished it by March or April 2008, adding that no one helped him before March 2008 and claiming that he later sent fragments of the code to Hal Finney, who couldn't testify himself because he had passed away in 2014. Much had been made of the evidence Wright was going to provide at this hearing. Even though the transcripts haven't been produced from the trial, we still know what evidence Wright produced thanks to the court filings in the lead-up. Arthur, most of the evidence came in the form of emails, of which either the provenance is questionable or simply consist of Wright telling people he was working on Bitcoin. But apart from that, what solid evidence did Wright produce to try and claim he created Bitcoin?
This bombshell evidence did not came at all. What was expected, for example, were credit card statements that would prove that Craig had bought the Bitcoin.org domain. No, so the only evidence that moved the needle a little was a handwritten meeting note with a BDO logo, presumably from 2007, where Craig mapped out the development and release of Bitcoin. You can feel it coming. Such evidence could have been written any time. And knowing that Craig writes his Satoshi evidence is always, there are no exceptions, but his evidence of his Satoshiness has always been created after April 2013, especially in 2013 was a highly productive year for him. So it's pretty much a certainty that this piece of evidence also has been created in recent days. What I found pretty interesting about this day in trial is that Craig Wright made the claim that he had filed in 2008-9 era, that he had been filing 2.2 million in Bitcoin intellectual property at ATO for his tax returns. And then you expect that Ira's counsel will not complain too much because it adds to his Satoshiness, but instead they came up with one of the ATO reports where it was noted that they rejected this claim of Craig Wright totally. There has been no filings whatsoever of any Bitcoin-related IP in 2008-9 era. And I was pleasantly surprised. Of course, I know there has never been, but this has been a lie that has been circulating also a long time.
Wright told the court that he spent over 600,000 Australian dollars on computing equipment for Bitcoin mining, said how Dave Kleiman's death hit him hard, and reaffirmed that he had never stolen from him or forged a document. And that was it. No bombshells, no real legal proof that Wright created Bitcoin, and certainly no evidence that someone was perpetrating a fraud against him. The BSV community had been cheated again. Finally, Friedman pressed Wright again on supposedly fraudulent emails from addresses associated with Wright's computer that the defence had laid at the door of Jamie Wilson, before resting his case and bringing to an end 3 weeks of testimony on both sides. The atmosphere in the courtroom the following morning, which would see closing arguments put by each side before the case was handed over to the jurors, was, as one observer put it, charged with anticipation, as almost 4 years of legal wrangling came to a head. Arthur, the jury were given instructions on how to go about their deliberations. What were some of the key things they would be deciding on?
Well, there were 7 accusations in total built up during the case. Breach of partnership, breach of fiduciary duty, fraud, constructive fraud, civil theft, unjust enrichment, and conversion. Now, and what happens then during a trial? At the start of the trial, the jury, they get a pretty hefty document, which is called the jury instructions, and the judge will then instruct and go through this. And if I remember well, I think it was close to 100 pages. It's crazy. But yeah, the document should help the jury in the decision-making process. For each of these accusations, a line of thought they should be following when deliberating about each accusation. Next to the jury instructions, they have this verdict form, which is in summary all the accusations again, breach of partnership, etc., etc. Then the verdict form is what we should fill in after the deliberations, which take place behind closed doors. So during these deliberations, the jury has access to all the exhibits of the case, and they are also allowed to ask questions to the judge. We have seen that happen a few times, not so much, but a few times. So when the jury has the verdict, then they will checkmark one of the accusations. They will appoint an amount of dollars in this case to that accusation. They will add punitive damages or not. They hand the verdict to the judge, and in this case Judge Bloom, who affirms it with a case closing order. And yeah, this is how it roughly goes in the process of a trial.
Vel Friedman's closing argument centred around the theme of choice, saying that Craig Wright's choice was made up when he found out his best friend had died. He chose to steal from him and cover up his theft with lies and forgery. Friedman then offered a summary of the story following Kleiman's death as far as Ira Kleiman was concerned, referring to some of the evidential highlights over the prior 3 weeks and opining that there were two Craig Wrights. The pre-litigation Craig Wright, who said that he and Dave Kleiman were partners, and the post-litigation Craig Wright, who said that he did everything on his own. While court reporter Carolina Ballado had put the total cost to Wright at close to $1 trillion if he was hit with the maximum award of damages claimed by the Kleiman estate, by far and away a US record for a civil case, without the clear smoking gun for the plaintiff, it was unlikely that the Kleiman estate was going to get everything they asked for. When Wright's lawyer Andres Rivero took the stand, in an upside-down, not your keys, not your coins face mask, no one was quite prepared for the line of reasoning he would take. He began by insisting that Kleiman's team had put forward not one shred of evidence that Wright was perpetrating a fraud, which begs the question of why his team's serial motions to dismiss the case based on lack of evidence were all denied. Rivero then claimed to a stunned court that the defence's entire case was predicated on Wright being a damnable liar and a damnable forger too. Rivero went on. So we have this heaping, stinking pile of lies and forgeries, and this is what the plaintiffs are basing their case on? Their case is that Craig Wright is a liar and a forger, but I'm going to use another word, fantasist. Rivero's argument was that if Wright was such a serial liar and forger, then how could the defence and the jury trust a word he said about anything? If he was lying about creating Bitcoin and lying about the early mining as much as they said he lied about what he did with the coins afterwards, then their entire case was built on the foundation of lies. Rivero then pulled out, almost word for word, what has become known as the Chewbacca defence, as shown in the popular comedy show South Park.
Ladies and gentlemen of this supposed jury, I have one final thing I want you to consider. Ladies and gentlemen, this is Chewbacca. Chewbacca is a Wookiee from the planet Kashyyyk, but Chewbacca lives on the planet Endor. Now think about that. That does not make sense. Why would a Wookiee, an 8-foot-tall Wookiee, want to live on Endor with a bunch of 2-foot-tall Ewoks? That does not make sense. But more importantly, you have to ask yourself, what does this have to do with this case? Nothing. Ladies and gentlemen, it has nothing to do with this case. It does not make sense. Look at me. I'm a lawyer defending a major record company, and I'm talking about Chewbacca. Does that make sense? Ladies and gentlemen, I am not making any sense. None of this makes sense. And so you have to remember, when you're in that jury room deliberating and conjugating the Emancipation Proclamation, does it make sense? No. Ladies and gentlemen of this supposed jury, it does not make sense. If Chewbacca lives on Endor, you must acquit. The defense rests.
The resemblance was uncanny, with Rivero saying, in reference to Wright's story of creating Bitcoin, so the plaintiffs want you to believe only this part, even though he lies and forges? That doesn't make sense. I'll say it again, that doesn't make sense. and if it doesn't make sense, you must find in favour of the defence. Rivera urged the jury not to consider whether Wright was a serial liar and forger, including in his dealings with the ATO, which really could have done without being mentioned again at this late stage, but whether there was a partnership with Dave Kleiman and whether Ira Kleiman had any claim on the fruits of that partnership. Rivera then began to make more sense, pointing to the lack of a smoking gun written contract, the fact that Dave Kleiman left no mention of Bitcoin in his will, and that nothing was found on Dave Kleiman's many devices, suggesting that Ira's multiple wipes of them meant he had something to hide. He then went off the deep end again, saying, "Their entire case is cherry-picked from what they are calling a stinking pile of lies and forgeries. How can you make a case like that? That's how they baked the cherry pie, using cherries picked from a stinking pile of lies. You can't call a person a liar and then just go to what the liar and forger says.
That does not make sense.
Rivera then brought out Occam's razor, which we have previously used to cut down Wright's lies and forgeries over the past 7 episodes, to suggest the exact same rationale, that Wright made the whole Bitcoin mining story up to avoid his issues with the ATO, only this time he tried to use it in Wright's defence, again saying that if this was true, then Wright had no case to answer, at least in the case of a partnership. Arthur, I've never been to legal school, so this could be way over my head, but it seems that Rivera was putting Wright in a situation where he was trying to clear him of the partnership claims by almost incriminating him for the fraud charges.
Yeah, this was indeed an hilarious moment during trial, the closing arguments of Craig's own counsel. But I noticed not only that it makes no sense, but the stinking pile of lies and forgeries. Every time when I saw that, Craig's counsel is telling Ira's counsel that they based their case on a stinking pile of lies and forgeries of a fantasist. Craig Wright is present and he is sitting there and he has to listen to his own counsel how they describe him as seen by Ira's counsel. So yeah, it is my firm opinion that this did not really help Craig's case.
Friedman was allowed a chance to respond to Rivero's summary, which he did, pointing to Wright's claim from 2019 about having more money than Rwanda to push the narrative that he stole that money from his dead best friend. He reminded jurors of his claim that Wright kept his supposed Bitcoin creation from everyone, including his wife, and then lied about it when it suited him. Friedman also addressed an image that had formed part of the defence's case, saying, "Mr. Rivero showed you racks of servers to mine Bitcoin, but he forgot to mention that is post-2013 mining. In 2009, you could mine on a simple laptop." And that, aside from one more reference to Wright's ATO forgeries, was that. The case, and the fate of Craig Wright's financial future, was handed over to the jury of 3 men and 7 women to decide, but not before confirmation that any valuation of Bitcoin was at the current rate, $50,000 at the time of recording, and not the valuation at the time of the supposed mining, as Wright's camp had requested. Friedman was said to have been confident of a verdict that day, but with so much evidence to wade through and so many points to consider, this was unlikely. Indeed, word came through that evening that there would be no verdict that day, and with Thanksgiving coming just 2 days later, there would be no more deliberating until Monday 29th of November. It would take more than a week's worth of deliberation for the jury to come to a verdict, and we'll cover it in the next episode. Arthur, without giving away the verdict, what was your overall impression of the court trial, given that it's been nearly 4 years in the making?
Yeah, Mark, seriously, it has everything for a Netflix series or a documentary. It has all the drama, it has forgeries, conspiracy theories, it has a cult believing in a cosplayer. Yeah, and then if you know what the verdict is, it makes perfect sense now afterwards. So everything will come together in the climax of the verdict.
Yep, well, we'll unpack the verdict in the next episode as the $1 trillion trial finally comes to an end. Arthur, thank you once again for sharing your knowledge and your insight.
You're welcome, Mark.
And I'll see you next time for the last time in this series.
Right on.
Don't forget, you can follow Arthur on Twitter at MyLegacyKit for regular updates on Craig Wright, or for more in-depth pieces on Wright and his activities, you can follow him on Medium, also at MyLegacyKit. A word of warning though, Arthur's work naturally contains spoilers, including key events that we'll be discussing in this series, so please be advised of that before you take the plunge. Thank you for listening, and we'll see you next time. Thank you for listening to episode 8 of Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. If you've liked what you've heard, we'd love it if you could rate and even review us on your podcast app of choice to help us spread the word. Make sure you subscribe to the podcast too in order to get the episodes the moment they drop. For the latest updates on new episodes and bonus material, you can follow us on Twitter at DrBitcoinPod, that's at DrBitcoinPod, and you can contact us at drbitcoinpod@gmail.com, that's at drbitcoinpod@gmail.com. If you'd like to support the podcast, why not drop us a few shekels or a few sats via the links in the description. Thanks once again for listening, and we'll see you next time.
You've been listening to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Written by Mark Hunter, with additional material by Arthur Van Pelt. Editing and production by Mark Hunter. This has been a Contented Media production.